Okay, we're live.
Thank you. Good morning, everybody. Welcome to the February 2020 meeting of the New York State Joint Commission on Public Ethics. Let's jump right in. Item 2, approval of the minutes from the January public session behind attachment A. Any question or comment?
No.
Okay, seeing none, can I have a motion to approve?
Commissioner Deering.
Thank you. Commissioner Deering. Second. Thank you, George. All in favor?
New York City.
WebEx, Buffalo,
And
Albany.
Great.
Okay, thank you. Item 3 behind attachment B.
So, staff has revised the proposed advisory opinion based on the discussion at the last meeting and comments we received from commissioners. So it's presented again for the commission's discussion and consideration. There should be, all commissioners in offices should receive a new version this morning with a change on page 3. Do you have that? Okay, and so the only change, this is in response to a comment from Commissioner Jacob yesterday, and what we really just did is took text from a footnote and moved it into the body of the opinion. It's on page 3. If you want to take a moment with that, but the point of the change is to say in the body of the opinion that the public officer only applies to state officers and employees. While we have jurisdiction over local lobbying and lobbyists who engage in local lobbying, we do not have jurisdiction over local officials under the public officers law.
Any questions or comments? Okay.
I think I'm in the right place here. Theoretically, the public officers law makes it refers a misdemeanor to receive a gift that's prohibited. The regulations create something called an interested party, which is not really referenced in the statute because the statute talks about, but it does talk about a public officer receiving a gift where under the circumstances it could reasonably be inferred that it was intended to influence. But what the regulations do is say if you're an interested party, that presumption then is that a gift is a banned gift. The statute makes it clear if you're a lobbyist, there's a presumption that a gift is improper. But here, the regulations now shift the burden of proof wherein someone is not a lobbyist but has an interest in a pending matter, then that's presumed to be bad and the person, or to be unlawful under the regulations, and theoretically it's a misdemeanor. I'm okay with the idea of creating something called an interested party and saying that in terms of our analysis here internally, that would be a persuasive or presumptive factor in determining whether or not under the circumstances it's reasonable to infer that the gift is improper. But I'm troubled by the idea that that also carries with it a potential misdemeanor. I don't think we have the authority by regulation to presume a misdemeanor, to shift the burden of proof on a misdemeanor. I think the standard should be the same as that which is written in the statute. If there's a gift from a person where it's reasonable to infer that it's improper or intended to influence, fine, let a prosecutor prove it. But I don't think by regulation we have the authority, or we should, shift the burden of proof and say, well, if you care about a pending matter, if you have an interest because you're not a lobbyist but you happen to care about a result, you're an advocate of some kind, and then you give a gift, that a misdemeanor, that the burden of proof on the misdemeanor is now shifted to the public official to prove that that gift was not intended to influence. Just to sum it up, I don't have a problem with the interested party designation. I don't have a problem with the presumption in terms of our analysis for an ethical violation. I do have a problem with what could be seen as shifting the burden of proof on a misdemeanor prosecution. Go ahead.
And so, I understand what your concern is, but this relates to, as we've discussed, regulations that were properly adopted by this commission in 2014 and run throughout several steps of our regulations. So it's something that the commission could take up and reconsider at a future date. But the idea with the regulations, as always, is that they don't create their own violation. They set forth how we interpret the law. And so it's not that it shifts the burden on a misdemeanor. It shifts the burden on whether or not the law has been violated, that we have to look at whether or not it would be unreasonable to infer it was not intended to influence. And so we would do that analysis, and the regulations, for the most part, are to provide guidance to the regulated community on how to approach this analysis. And so they've been in effect for, for 6 years now without, real discussion about the concerns of raising, as well as there's no criminal prosecutions under 73.
No.
So I think my only point is, I think that this warrants further discussion, but we can do that at a future date when we can discuss the 4 sets of regulations that use the term interested source that were adopted back in 2013, 2014. But the advisory opinion is relying on the regulations that were adopted by the commission.
Well, I would appreciate a footnote that made it clear that the presumption that's created in the regulation is not intended to create a presumption or shift the burden of proof in a criminal case.
Marvin?
I'm unclear as to why Commissioner Yates differentiates the criminal from the ethical. Even for our purposes, if the statute does not allow burden shifting and presumptions, why should we assume that we can go forward on that basis in cases involving ethical matters, but it does not exist in the criminal context? If it doesn't exist because it's not in the statute and because the regulations are going too far, it should apply across the board. No burden shifting and no presumption.
Well, the reason I distinguish the two is I think it's fair enough for a regulatory body to say that in applying the statute and looking into whether or not an interested source whether or not a gift to a public official from an interested source is suspect, it's fair enough for us as a regulatory body to say that one of the factors we're going to look at and give weight to is whether you're an interested source and whether or not the recipient was aware of it. And I don't mind that burden of proof being shifted when you're talking about an ethical violation that we're administering. I draw the line, though, on somehow or other it being read by anybody that we then have a criminal referral or that there's a shift in the burden of proof in a criminal prosecution.
I'm still unclear. If we were in litigation before a hearing officer on in an ethical context, would the hearing officer be able to rule on burden shifting and presumptions as you described, since it's not a criminal matter? Whatever we do internally, we do. I'm talking about what happens in the ethical context. Is it the same as in the criminal or different? And in litigation, when we're litigating an ethical issue, why should we apply your reasoning differently?
So, Commissioner Jacobs, and Commissioner Yates, to both of your points, we considered the issue of the burden and the presumption when we adopted these regs several years ago, and these were fully vetted by the full commission at that time. We went through the SAFR process, we had comments, we worked with the Legislative Ethics Commission on these regulations, And at the time, after analyzing these thoroughly, everyone was very comfortable with the way that we set it up. To answer your question about a hearing, when we allege a violation of law, we are alleging a violation of 73.5A, not a violation of our regulations. And so that is the analysis that the hearing officer would apply in that case. The regulations, for the most part, are used to put parties on notice on the way that we interpret the law. And the presumption was created because in this commission's view at the time, if someone has business pending, regardless of whether a lobbyist, but if they have business pending before the state agency at which the official works, and that entity that has the business gave a gift to that official, then we thought that it was fair to presume that under those circumstances, it could reasonably be inferred that the gift was intended to influence them. And so the idea was that you should not accept that gift unless there were some circumstances that would overcome that inference. The wording that we used was presumption to make the analysis very clean and clear. If the commission would like to, at a future date, reconsider those regulations, that is obviously something the commission can always do. You certainly can add a footnote to this advisory opinion, but I have cautioned against it. I think the more appropriate way would be that if we readdress those regulations to put something in the regulations to the extent that if there is a basis to make a distinction between technical enforcement proceedings and criminal proceedings, it's done in the regulation rather than just this one advisory opinion, because we have issued, again, many advisory opinions over the last several years which rely on the way we've analyzed the regulations. So to just insert it into this advisory opinion may suggest something that isn't necessarily the case, and we want it to go back to the other advisory opinion. So I think, again, the proper context to examine that issue would be the regulation. And certainly we could bring those back to the commission at a future date.
So I just want to add to what Monica said, and to the three people who might be listening to this meeting outside of those participating. There is no burden shifting here. There's absolutely no burden shifting. The burden always remains on the commission to prove a violation of law. So I don't know why this moniker is being thrown around, but the regulations don't shift the burden. The burden is on the commission. That's the way it's always been for the last 6 years, and no one has ever suggested that it's been anything else other than that. I just want to make that clear to those who might be listening in.
You couldn't be more wrong. You could not be more wrong, because the statute reads in two different ways. I mean, the regulations read in two ways. If you're not an interested party and not a lobbyist, then the rule is that we examine it to see whether or not, under the circumstances, it could be reasonably inferred that it was intended to influence. On the other hand, if you're an interested party or a lobbyist, then the regulation reads that that it's intended to influence unless it could be proven that it's not. You just look at the two sections in the regulations. They very clearly shift the burden.
But the burden at a hearing.
The burden at a hearing is on the commission, is on the commission to prove a violation. The regulations give guidance to people saying, listen, if you go ahead and do this, if you go ahead and engage in this transaction, the commission will most likely, it still has the burden of proof, but it will most likely find that you are going to be found in violation of the law. It's merely guidance as to how the commission is going to view a given transaction under a certain set of circumstances.
I need to have the reg in front of me, but I'm sorry, when you create a presumption, I could read you the language.
I understand what you're saying, but the presumption created in the regulation, it doesn't change the commission's burden at a hearing to prove a violation of the law.
Let me make this simple for the three people who obviously
I think we have more than three people.
Okay. Let's say that you have to prove beyond a reasonable doubt that a person knowingly possessed drugs. But then you say, by the way, if there are drugs in a car, you're presumed to know they're there. Now, you can quibble about whether there's burden shifting or not. You still have to prove beyond a reasonable doubt you had the drugs. But when you create the presumption, you have shifted burden because there's a presumption that the prosecution, or in our case, the commission, can rely upon. So I don't care whether you quibble and call it a burden shifting or not a burden shifting. It's a presumption that shifts the burden.
It's also a question whether the person with the burden, i.e. the commission, is aided by reason of the presumption. Presumptions are powerful things, and to overcome them, one is at a disadvantage. So let's not get lost in the burden shifting. I agree with Commissioner Yates.
I mean, the regulations could have just as easily said, without using the word presumption, that generally speaking, in a given situation with this set of facts is probably going to be a violation of the law, a violation of the law. That's how the commission is generally going to look at these things. I mean, if you're hung up on the word presumption, perhaps that word can be changed, but I don't understand. If we had written the regulations to say that given circumstances A, B, C, and D, this will, absent other circumstances, most likely be found to be a violation of the law, so that's how you should guide your behavior, and that's how you should construct your transaction so as to avoid that result. That's what the regulations are doing. It's not shifting. It's not shifting a burden at all.
Right.
I'm sorry, let me read you the regulation. The regulation says, when you're talking about a covered person, meaning a public officer, and receiving a gift, not from a lobbyist, but from someone who has an interest in the outcome of legislation or matter, so they're an interested source, that it says such gift is only permissible if under the circumstances all of the following criteria are met. Criteria 1, it is not reasonable to infer that the gift was intended to influence the covered person. I could hardly write a presumption that's more clearly a presumption than that.
I don't think we're disputing that the regulations set forth an analysis that includes a presumption. I think what we're discussing is how do the regulations interplay with the law when we're bringing in enforcement action, or when if ever, we made a referral for a criminal prosecution. In both of those cases, and this is how it has played out over the years, it is not the regulation that we're enforcing. We are enforcing the law. And the burden will remain on JCOPE in those hearings to establish the violation of the law. The regulation doesn't, it just reflects how the commission looks at the law, but we still have the absolute burden to prove that they accepted a gift under circumstances where it would be reasonable to infer it was intended to influence. We will always remain with that burden. So while the regulations lay forth a guidance analysis that people use to determine whether or not to accept gifts or offer gifts or solicit gifts, when JCOPE is bringing a case or a prosecutor is bringing a case, they will have to enforce the law, which doesn't have the presumption language in it.
It's hard to say you're enforcing the law when you've created a fictional entity called an interested source, which is nowhere referred to in the law. There is no such thing as an interested source. It's a way of extending the ban against gifts from lobbyists to another group of people who are not lobbyists. Now, I told you at the beginning, as an ethical matter, I don't really have a problem with that. I think that we should scrutinize carefully, and we should protect against gifts from people who have an interest in legislation, even if they don't happen to be a lobbyist. But let's be clear, I mean, it's not a defense to my concern about an overexpansive possible reading of the regulations to say I'm just following the law when you've created a fiction that's not in the law. So I reiterate, I would request that there be a footnote in the advisory opinion to say that the regulations with respect to the interested source gifts are not intended to shift the burden of proof. I would say in criminal matters, but if the rest of the commission would like to extend it generally, that's a different thing. I would probably go along with that. My motion was only to limit it to criminal matters.
If the commission wants to put in a footnote about burden shifting, the commission can add a footnote about burden shifting. The regulations are the regulations, and the commission has adopted them, and they are currently our regulations. So if the commission wants to reconsider the regulations, we can always reconsider them. It's a separate issue from whether or not you want to add the footnote. I would be careful about adding a footnote that talks about what our burdens are, because our burden is established in the administrative procedure law as to what we have to establish, and there are criminal and penal laws as to what burdens are prosecutors to establish. But if the commission wants to add a footnote, I don't think it changes the import of the opinion.
Well, just wrap this up by let's be practical. There are a heck of a lot of people out there who have an interest in legislation and regulations and state matters. A heck of a lot of people. There are a vast number of people who don't happen to be lobbyists, but they have an interest. And I just don't think that we ought to guard against the possibility that someone would criminalize the receipt of a gift based on a presumption just because the giver happened to have an interest in legislation or a regulatory matter.
Don't the regulations define a civil offense and a criminal matter? The state will always have the burden of proof.
So what do you think? The statute calls it a misdemeanor. I mean,
in a criminal prosecution, the judge wouldn't instruct the jury on these regulations.
especially not if we put my footnote in, you're right.
There's no need for a footnote. The regulations, there's no need for a footnote. The regulations do not set forth their own. I mean, you have when you go into a criminal matter, the court is going to look at the law. The court doesn't need a footnote in an advisory opinion to be told that it needs to look at the law rather than the regulations.
Well, let me put to you, if there's a misdemeanor that's being prosecuted and the basis of the prosecution is that someone had an interest in legislation and they gave a gift to a legislator, you're telling me that because the law only refers to gifts from lobbyists, that prosecution would be dismissed outright? This judge would sit there and say, doesn't matter that an interested party gave a gift.
I think the way it would work is that the prosecutor would be looking at all of the evidence related to that gift and applying 73(5)(a). And if under the circumstances that interested party gave a gift when they had business pending, and there are other circumstances that lead to the conclusion that you could infer an intent to influence, then that's what the prosecutor is going to rely on. He's not going to rely on a presumption that's created in the regulations. He's going to rely on the evidence in support of the violation of the law. The presumption doesn't really help shift burdens in the proceedings in any way. It's really just it's an analytical tool to put people on notice on how we interpret the law, but it doesn't change our application of the law when we go to a hearing.
I'm sorry, I've written too many laws over the years to be told, don't worry, a prosecutor wouldn't do it that way. I don't know, maybe it's too arcane for me to make the reference, but if any of you remember Guys and Dolls and Marlon Brando not taking the bet on when it was Danish, he said that his daddy told him that someday someone's going to say that a cricket's going to whistle in your ear, and don't take that bet because as improbable as it seems, it's going to happen. That's the way I feel about this. Look, I already said it. I don't want to keep repeating myself. All I'm telling you is if you're asking for a vote on the advisory opinion, I'm voting no unless that's taken care of.
Okay, but we're not voting today, so no worries. Let's move on to attachment C, regulations.
As discussed at the January meeting, the Commission has taken, the last year's experience with the lobbying regulations and come forth with a set of proposed revisions that reflect not only concerns that have been raised by the regulated community, but issues that are simply technical cleanup that we have identified, as well as some technical filing issues that have come up. But there are some substantive policy changes. Carol's going to go through those, but we think this is the proper course of action for the Commission to engage in a public discussion about these regulations that were thoroughly vetted through a seemingly interminable process initially, but the goal today, if we determine to take a vote, would be to simply start a administrative rulemaking, and this would not complete any changes. But I'll let Carol take the lead on discussing the proposed revisions. You have a copy in your materials as well.
Okay, thank you. So, assuming the commission decides to go forward with the rulemaking and initiate the SAFA rulemaking process, our goal and our anticipation is that it would be effective January 1st of 2021, this coming January, which is the start of the next biennial period. I mentioned last time the big changes really relate to direct and grassroots lobbying and social media. I'm going to go through those first, and then I'll get into some clarifications we're seeking to definitions like designated lobbyist, contractual client, and coalitions. So first I'll start with direct lobbying. The regulations, obviously direct lobbying is reportable. They clarify that individual lobbyists must be listed on filings, except when an organization uses the organization's social media platforms to directly lobby a public official. In that case, the activity is reportable, but no individual lobbyist would need to be listed on that filing. We also, the current regulations have an entire section dealing with lobby days. We felt that was important at the time since we got so many questions. However, in hindsight, having its own section may have overemphasized a lobby day. So with these regulations, we're going to incorporate lobby days into direct lobbying because it is just another form of direct lobbying. So we're going to eliminate the special section with that. We'll clarify and keep the same points about lobby days, but we'll just incorporate them into the direct lobbying section. Basically, if an employee or a designated lobbyist speaks to a public official at a lobby day, they get listed as individual lobbyists. That's a key point. So mere presence at a lobby day does not make you an individual lobbyist that needs to be listed on a filing. We also continue with and include the language that clarifies that volunteers or mere members of an organization do not have to be listed as an individual lobbyist. That's generally what we've done with direct lobbying. Moving on to grassroots lobbying, we made some changes there and some clarifications. Obviously, it's reportable lobbying. We clarify that. We also make a change. So now, individual lobbyists sometimes have to be listed based on grassroots lobbying activity. We're going to amend the regulations, that's our suggestion anyway, to say that no individual lobbyists are required to be listed based on grassroots lobbying activity alone, except for two things. A retained lobbyist that can be identified as speaking for the client, this might be like your paid endorser, or in the social media context, which I'll get into in a minute, if a person is specifically retained for their personal social media activities, they would be listed as an individual lobbyist. But for everything else, no individual lobbyists need to be listed, just the entity reports it as an activity and lists their expenses. So now moving on to social media. We're making a pretty big change here. Social media in the current regulations does deal a little bit with personal social media. With the changes, we're making them exactly the same, whether they're direct or grassroots lobbying. If you're lobbying through social media, if your social media message is conducted by an organization using the organization's social media platform, that's reportable by the organization, but no individual lobbyists need to be listed. There's no face to that lobbying. You do not have to list an individual lobbyist, but it is reportable. For personal social media activities, this is a big and kind of a key change, which we hope will simplify things. Personal social media by an individual, presumptively not reportable, unless, again, the person is retained specifically for their social media activities. So you're hiring someone to lobby for you using their social media platform. In that case, that person becomes a lobbyist, a retained lobbyist, for the paying client, listing themselves as an individual lobbyist. I just want to point out that in the regulations sent to the commission, there was, on page 36, subdivision B was mistakenly left in there. We're making them exactly the same. So, and we have made this change on the website. So the current version on the website is accurate. And again, just to reiterate, we're making it exactly the same. Personal social media is not reportable.
When you say exactly the same, Carol, when you say exactly the same, you mean the way we're going to treat personal social media for direct lobbying and grassroots lobbying are going to be treated exactly the same?
Exactly. Exactly. Yep. The presumption is it's not
so
reportable.
Section B on page 36 was just mistakenly included, so we're deleting that.
Right. So personal social media for both direct and grassroots is presumptively not reportable unless the person is retained or hired specifically for their social media activities. This is true for both direct or grassroots. So personal social media of like employees or designated lobbyists, they're not reportable by an organization. It's only if you actually hire and retain an outside person to use their personal social media platform. That's a key change and hopefully really simplifies things. So those are the two kind of major changes we're making with for social media, and also the policy changes about direct and grassroots lobbying. And I can get into now the changes we're proposing for definitions. If people have any questions, just let me know. Okay. So for designated lobbyists.
Hang on one sec.
Okay.
She's going to turn to definitions. If there's a question, go to what she just covered.
Yeah, no, let her keep it.
Okay.
All right. Okay, go ahead.
Okay, so those are the kind of policy changes we're making, and then we did make some changes that were more for clarification purposes. One of them is the definition of designated lobbyist, and we clarify, and that is on page 6. So we make some clarifications there, and we're basically clarifying that you can designate yourself to lobby on your own behalf, and an organization can designate a person to lobby on their behalf. This would include board members. Are there any questions on that?
Go ahead.
I see you did change the definition of designated lobbyist a little. I don't think you completely took care of my concern. I've raised this repeatedly for the last 10 months. I did it publicly last time, and I'll do it again now. And I'll start it with a question to you, and that is, you now say that a designated lobbyist is a person who's selected, appointed, named, or otherwise intended to lobby on behalf of themselves or the organization. But then you go on to say it would include a board member, and whether compensated or not. My question is, when you say it's included, does that mean that a board member who's not compensated, who is not going to be considered to be a designated lobbyist unless they were selected, appointed, named, or otherwise intended to lobby? Or are you saying that if a board member, the reverse reading could be, a board member, uncompensated, is per se a designated lobbyist when he or she directly lobbies, regardless of whether or not they were selected, appointed, named, or otherwise intended to lobby on behalf of the organization?
Right. Okay. So yes, to the latter.
Just so it's clear, the latter. Okay, then that's my concern, and that's the same point I've raised repeatedly, and I'll do it again. And that is, an uncompensated board member in a not-for-profit who spends no money and receives no money, but has direct contact with a legislator or a state officer, so that it's direct contact, that if on their own they say, yeah, I like volunteer fire companies, they should get some money, that even though they're not acting in coordination with, at the behest of, at the request of the organization that spent the $5,000 has no idea that there was this social contact between the not-for-profit board member who incidentally said, had direct contact with a public official, that nonetheless, all of a sudden now, this person becomes an individual lobbyist who has to be named in registration, has to take training classes, is barred from maybe, depending on what other kind of positions that person has, from doing lobbying. All of those restrictions and burdens now fall on the an uncompensated board member merely because he or she had contact with the legislator, even though it was not at the behest or request or in coordination with the organization.
Right, so we're very happy to discuss this. This is something we came up with. We viewed board members who lobby, they have to lobby. It's not just being a board member, but board members who do engage in lobbying activity on behalf of the organization, that type of activity should be reported, and that person is a lobbyist in that case, if they lobby.
On behalf of the organization, that's the key. It's interesting, if you go back a page to page 4 instead of page 6 in the booklet, when you talk about beneficial clients, a client who incidentally is receiving a benefit lobbying, in order to protect those people who may have an interest in the outcome, you specifically say if it's at the request or behest of the lobbying activity. I've repeatedly said, why not, when you're talking about an uncompensated board member, say that there's a lobbying activity if it's done at the behest or request of or in coordination with the organization, with the lobbying organization, so that incidental conversations about something that a person may have a passion about. Let's say someone wants the Child Victims Act passed, as an example. They may be on a board, and they may talk to a member at some point separately about it, but if it's not in coordination with any kind of lobbying activity, it's just a conversation, I don't see why all of a sudden that person has to take the training classes, has to file biannually, has to be listed in a registration statement, etc. They're just a citizen advocate.
So I just want to clarify for everyone's edification, this is the current position that is in the existing regulations. Nothing that we're proposing is changing this. So what Commissioner Yates is suggesting is that we change the position the Commission's already adopted. I just want everyone to understand that. So that's...
You're amending the section.
We are amending the section, I agree. I just want to make it clear that the rule right now is that an unpaid board member who engages in activity, attempts to influence elected officials on pending legislation, has to be listed on filings, and as you mentioned, would be subject to whatever provisions apply to anyone who's listed on filings. They don't actually have to file anything. They just have to be listed on the filings. That being said, I just want everyone to understand where we were. So these issues are definitely something the Commission has to discuss, and I think it's a policy decision for the Commission, as it was the last time around when the Commission adopted these regulations, and it's weighing the burden on the individual who serves on a board as an uncompensated board member versus the disclosure about their meetings with state officials on pending decisions such as legislation. And that's really the question. And then if the Commission weighs in favor of, thinks a new balance has to be struck, then we can propose amended language and go from there.
When I was new to the Commission, I went to Seth and Martin, and I raised this question. And I was told, no, these regulations have been out there, they've already been proposed and looked at for a while. Why don't you wait until the next time that they're going to be amended, because it's a little late in the game now to start amending these things. So I bided my time for 10 months. Now that it's being amended, I'm being told, oh, but that's the way it's always been. I'm sorry, that's unacceptable.
That wasn't my point. I just wanted people to understand the status. I'm not saying it's, I think that these are policy issues the Commission has to consider. I was just making it clear for some that might not have understood. This currently is in the regs. This would be a change.
Commissioner Fisher would like to speak.
My amendment that I would offer would be where on page 6, where it says this includes, let's see, I gotta find it, a board member, director, or officer of a client, whether compensated or uncompensated. I would say in the case of an uncompensated board member who engages in lobbying activity, that person is a designated lobbyist if he or she is acting at the request or behest or in coordination with the lobbying organization.
So, and this is the language that currently is in the definition of beneficial client. And so that language is there, you can take a look at it, it's on the prior page. Staff added that language as part of the revisions in the last, with the original regulations in response to concerns that were raised in the comments about people being captured as incidental beneficiaries. In other words, the way that beneficial client was originally drafted, it could include parties who had nothing to do with the lobbying effort, but stood to benefit from whatever changes in the law took place. And so we added that language to make clear we weren't going to capture incidental beneficiaries. Staff doesn't have that concern necessarily with designated lobbyists, because they are intentionally engaging in the meetings with the state officials, but it's certainly something the commission could consider. We do have concerns that that language might create problems in terms of policing the activity, because board members may be engaging in conduct, and we would have to establish that they actually had the communications and conversations with other employees and members of the board before they had the meetings that they had to engage in what we would otherwise call lobbying. But that would be staff's concern with that language.
Well, but Monica, you just said that it wouldn't capture people who are intentionally engaged in meetings with the public official. I'm sorry, but it would. You're talking about meetings where there's other lobbying activity going on. Presumably there's a group of people there at that time, and you're part of a meeting. That's different from what I'm talking about. I'm talking about where it's not in coordination with the organization at all. It happens to be somebody who says to a public official, giving aid to Puerto Rico right now would be a good thing.
Yeah, Commissioner Fisher?
So I wanted to ask for clarification. I understand the example of a fire department and somebody that's on that nonprofit board, but it seems a little fanciful because, if I understand correctly, we're only talking about board members of a lobbying organization. So of all the nonprofits I've been on, probably 20, only one has been a lobbying organization that spent more than $5,000 and registered. So it doesn't really put much of a burden on all the folks that are on a nonprofit that is not registered. And if it is registered, it seems good governance for the board members to understand that there's a higher level of scrutiny around their interaction with legislators. And that since somebody is spending money to influence legislators and hiring somebody to do that as a professional person, usually, that board member and all the board members should perhaps take into account the fact that they are spending money and they need to be careful. And if they do enter the realm of lobbying for some law, that will have to be reported. And it shouldn't be, so burdensome that it keeps that unpaid board member from carrying out his or her fiduciary responsibilities and trying to get more financial support for their organization. But it doesn't seem like it's going to be the normal case that nonprofit board members are suddenly going to be placed under this undue burden.
Respectfully, there are a ton of organizations that are either 501c3 or 501c4, or they split in half and they create sub-entities that are 501c4. The American Cancer Society, Blue, Red Cross. I'm sorry, it's very common to have not-for-profit who hire a lobbyist. They're engaged in lobbying activity.
And I think that those boards should probably leave the lobbying to the professionals. But that's just my opinion, just my own experience.
Okay, can we continue?
Sure, so,
Is my motion in
There's
order?
no motion. No motion, we're not voting.
No, we're not.
Not yet, no.
Okay, if we're not voting, fine. Once again, I'll say that without some adjustment to that, I'll vote no on the proposed resolution.
so I should proceed?
Yeah, keep going, please.
Okay. So we also clarified contractual client. We had gotten some questions on this, so we clarified that a contractual client is the entity that signs the agreement or enters into the lobbying agreement with the lobbyist. They often pay the lobbyist as well, but they don't always, that's not necessarily the case. Sometimes the beneficial client might contribute to the lobbying, might actually pay for the lobbying. So we make a clarification there. We also made some clarifications relating to coalitions. Coalitions are on page 59 to 63. We clarified the definition to be clear that a coalition not only just pools funds, but often pools resources. So we add the term resources. And we also define what constitutes a member of a coalition, which would be anyone who provides funds or resources to the coalition, including donating services or incurring expenses on behalf of the coalition.
Carol?
Make those clarifications, yes?
I just want to point out that these two changes that you're discussing, I think are really just to reflect our original intent when drafting the regulations, and that we noticed over the course of the year that there could be either confusion or differing interpretations about what the language as was adopted actually says. So we took the opportunity here to clarify what was always our intent to cover. And so these, while are certainly substantive, don't reflect a change in our position.
That's absolutely correct. Some of these changes really are just to clarify our position and make sure, you know, as Martin expressed earlier, this was a big undertaking, so we think it's appropriate a year later to make some changes and open this up for discussion. Those are the only changes in the regulations that I was going to, the lobbying regulations that I was going to get into today. We also are suggesting amending Part 938 relating to source of funding to accomplish the two things that we've previously discussed, and the commission has language on that, and that is to exclude from disclosure contributions specifically earmarked for lobbying activities outside of New York State and restricted from the use in general funds. We've gotten some questions on that, and that has come up. So that is language that you've had before you several times, I believe. So we have the language before you today. And then we're also clarifying the issue of anonymous sources and saying that they basically are not allowed. You can't just, you have to identify who the source is. And that's on page 13 of the regulations you have in front of you. That's all I have as far as highlighting what the changes are. We can obviously go through provisions if you'd like, or have further discussion.
Does anybody have any comments, any further comments on this? All right, I think we're going to hold on voting whether or not to move forward with this type of process until next meeting, so everybody has a little more time to chew on all of this stuff, and we can take it up again next month. But at that time, I will be looking for a vote to move forward with the SAP process. Before we get to new and other business, I have a statement that I would like to read. I, along with my fellow commissioners, am frequently frustrated by the confidentiality restrictions in the executive law is to prevent us from publicly disclosing more information about the work of the Commission. These restrictions limit the Commission's ability to correct uninformed and false statements, mistaken impressions, and baseless conjecture reported in the media about such work. The Commission has repeatedly suggested amendments to the law to allow the Commission the flexibility to disclose more information and respond to questions regarding investigations, particularly when allegations are already in the public domain. Instead of seeking new statutory language, I am today forming a committee to revisit the Commission's interpretation of the existing provisions in the executive law and amend the Commission's regulations relating to access to publicly available records. In addition, this committee will undertake a review of the Commission's procedures that protect the confidentiality of its records and proceedings, including the recent recommendations of the Office of the Inspector General. I will be contacting commissioners over the next few days to inquire about their willingness to serve on the committee and hope to move forward with a proposed rulemaking within the next few months. Thank you. Let's move on. New and other business.
Yes, I'd like to respond to your statement, if I may, Mr. Chairman.
Go ahead.
In fact, I'm going to make a motion today. By way of introduction,
You got to speak up a little, Gary.
yes, can you hear me?
Yeah.
Can you hear me now, Mr. Chairman?
Yeah, go ahead. Thank you.
I have some observations to make, having been on the commission for its entire existence after 31. Dressed up in the finery of confidentiality, a culture of secrecy permeates certain quarters of state government, perpetrated by a cult of secrecy. The culture of secrecy was not initiated by the current administration, nor is it unique to it. Despite decades of reform to expose state government to what Brandeis called the disinfectant of sunlight, secrecy persists. Confidentiality has its important place, but the propensity for unwarranted secrecy has persisted since long ago, and we should be vigilant in resisting. Ironically, this commission has been both frustrated by the secrecy of other agencies and itself an enabler of gratuitous opacity. The commission has experienced the disingenuous prosecutor, who in private demands we stand down for investigating, but in public attacks the commission for being ineffective. You've already made an allusion, Mr. Chairman, to that. The commission has experienced the secrecy of the attorney grievance machinery. Even as a state enforcement agency, the commission cannot divulge if the commission has made a complaint against an attorney. If no action or action short of a public sanction is taken, only the most cryptic and deliberately opaque explanation is proffered by the grievance machinery. How can ethics enforcement be effectively coordinated if the commission has to go to court under the judiciary law to have information shared with it? Most saliently is the commission's experience with the Inspector General's office. Imperious, operating in secret, akin to a latter-day Star Chamber. Now, you've established a committee. I say today we can turn to a detached view of the commission. And when we do, we find the quintessential exemplar of the secrecy culture. Propounding in court proceedings the proposition that secrecy is paramount, and refusing to divulge its votes, although the statute permits it to do so. Secrecy has now reached a new zenith of absurdity within the commission, with commissioners being told that information our staff has is off limits to commissioners. I have asked if a request has been made for my FDS. That's secret. I have asked if the Inspector General has asked for the FDS of any commission. That's secret. To the extent our statute gives the commission latitude to reform itself, it should move vigorously to do so and not wait 3, 4, or 6 months. I made a proposal at the last meeting and I urged immediate action. I also want to point out, as you have stated, the statute itself should be closely scrutinized, but not just our statute. The statute creating the Inspector General should be the object of very close scrutiny. So far, only palaver has emanated from the legislature. The temporary president of the Senate and the Speaker have not even filled their vacancies. The so-called investigation of the leak has engendered nothing but cynicism and further undermined the credibility of ethics guidance and enforcement in the state. And I want to say, Mr. Chairman, with all of the emphasis I am capable of mustering up, I cannot fathom how this commission can credibly preach ethics and enforce ethics without policing itself. As Commissioner Weissman has often said, we're supposed to be an ethics commission. I move adoption right now of an interpretation of our statute that permits the commission, by majority vote, for good cause, to divulge information to the public. And I have a second motion to make after this one is disposed of.
So let me just comment for 1 second, Gary, and you know I have profound and the utmost respect for you. I am going to oppose your motion, not because I may disagree or agree with it substantively, but I think that at this juncture, it's premature, and I would instead suggest that your comments prior to the motion suggest a willingness and desire to serve on the committee that I'm establishing, so I accept. And thank you for that. But be that as it may, you have a motion, so is there a second?
Well, let me interrupt, if I may. I withdraw the motion, and I appreciate your warm words. They're very meaningful to me, Mr. Chairman. But I believe that a deadline ought to be established within which this analysis is going to take place. We have ample experience with other issues, including a major personnel issue, where our deliberation seems to be going on interminably. So I'll withdraw the motion for today, but I would hope by the next meeting that we can have at least a preliminary report from this committee.
That sounds fair to me, Gary.
All right, I have a second motion. I'll withdraw the first motion, but this one I want to vote up or down today. I move that the interpretation of our records access policy be changed effective today to preclude denial of any information to commissioners. And let's get to the bottom of this issue of the FDSs.
Is there a second for that motion, or any comment or question? Hold on 1 second, Commissioner Weissman.
Yeah, I have two things. I'll second the motion, but it seems to me that transparency is a two-way street. I believe, and FOIL, we all know that FOIL doesn't apply to us, but I believe under FOIL that if somebody makes a FOIL request, the subject of that FOIL request can obtain certain information, not information that constitutes personal information, unwarranted personal information, but they can find that kind of information out. So what Gary's doing is just leveling the playing field, I think. So that's why I'm seconding the motion.
Okay, so George seconded.
Commissioner Horwitz.
I'd like to know from Commissioner Levine, you mentioned something about FDS access. Is that what this motion is about?
Yes. You might want to have either Martin or Monica explain what the current policy is that has occasioned the motion.
Commissioner Levine requested to know whether or not his FDS had been requested by anyone, and we explained to him that it's been the policy of JCOPE as well as its predecessor that that information is not disclosed. So we do not disclose to any FDS filer whether or not their FDS has been requested or by whom. And as everyone knows, we receive multiple requests for these public records throughout the year. In addition, we receive subpoenas from various law enforcement agencies that are conducting investigations seeking FDSs. And so the policy of this agency, which may not be the same as other agencies, but I haven't thoroughly exhausted that research, it has always been that we do not disclose to an FDS filer whether and by whom their FDS has been requested.
And Mr. Chairman, can I ask a follow-up question, please?
Yeah, go ahead.
Monica, can you explain what the policy rationale is for the Commission's current position?
Well, again, it has been driven in part, I mean, it predated JCOPE, so we continued the prior policy, which made sense to us because we don't know, when we get these requests, what type of investigation and whether it's covert or overt that's going on when it comes from one of our law enforcement partners. And under our current law, the public version of the FDS that's available and the version that's available set by subpoena, which is redacted, they're now that the categories of financial information are now publicly available, there's very little difference between them. So sometimes law enforcement subpoenas us, sometimes they make requests. We obviously also get requests from agencies about their own staff. We also get requests from members of the public, and we get requests from the media. Walt could speak better to who else requests FDS filings, but it's been our position that the identities and the facts of those requests should not be disclosed, and that's been the practice.
And is the reason for the confidentiality around the party that makes the request, does that have anything to do with the integrity of a whistleblower complaint or an investigation by a law enforcement or other regulatory agency? In other words, if a member of the public makes an FDS request with the potential goal, whether it's a member of the public or, for example, the press, wants information because they're in sort of a whistleblower context or an agency is conducting an investigation, is the policy behind the confidentiality to make sure that the potential target of the investigation doesn't somehow get tipped off to the investigation, whether that's a member of the commission or anybody else? Is that one of the policy rationales for this?
Yeah, absolutely.
Okay, well, I'm not going to vote I'm not going to support the motion for that reason, because I don't want to in any way compromise a member of the public or the press or an agency doing what they feel they need to do for due diligence purposes. As Monica just pointed out, most, if not all, of the meaningful information of the FDS is already public. So the only thing by Commissioner Levine's motion we'd be doing is outing the party that's made the request, and I don't understand what the public value is in doing that, so I'm not going to support this motion. So can I just
Mr. Chairman, if I may, I'd like to begin with a threshold issue, with a question. Has this commission ever adopted the policy as enunciated by General Counsel?
No,
I
this
am
is
voting
not,
commission.
it's not a rule or regulation. The Records
Well,
Access
who's got this
regulations do
policy?
not, sorry, the Records Access regulations set forth what information is disclosed, and this information is not included, and obviously those regulations were adopted by the commission and there was a committee at the time who put those forward. But I don't recall, and I don't know if you were on that committee, whether or not the issue was discussed. But it is not a rule or regulation, it is a policy, and so it can be changed. But I think,
Policy established by whom?
It was established by our predecessor and remained in place. It was
In other
established
words,
and followed
what
by the
you're saying
Commission
is,
on Public Integrity.
it's staff's policy.
I'm saying it was the Commission on Public Integrity's policy, and we continued it.
Mr. Chairman, might I suggest that because it seems that there are actually some more complicated nuances to this issue that perhaps this issue be taken up by the committee that the chairman mentioned that he's going to create, and maybe Commissioner Levine would withdraw the motion to have the committee take that issue up.
Yeah, I mean, I think that's a worthwhile suggestion. Gary, there's a motion and a second here, so we can have an up-down vote. I will tell you that I myself at this juncture am uncertain as to what I think the proper outcome is of this question. And I would be curious to know, Monica, what other similar agencies do in regard to this exact kind of question before I would vote in favor of it. So I do think, Gary, it's premature. We can take a vote if you wish, since there has been your motion seconded already, but that's on you.
You and Dan have suggested a sensible approach, again, if the discussion, the analysis, and the determination is not on some interminable timetable. But I just want to say, I will withdraw the motion for today, but I just want to have an understanding right now. In the executive session, if I put the question, because it's an investigatory matter, has the State Inspector General requested the financial disclosure statement of any commissioner? I'm going to be told that's a secret and the commission cannot be told? Even the other commissioners whose FDS was not requested? Is that the position of General Counsel?
I would be more comfortable discussing the documents that are produced to the Inspector General's office in the executive session.
All right, I withdraw the motion for the time being. Thank you for your consideration, Mr. Chairman.
Thank you, Commissioner Levine. I will add, just in a final note on this, that I do not believe in interminable debate or discussion, as I hope everyone has seen throughout my tenure as chair, so it will not be interminable, Gary, just to give you some comfort on that.
Well, thank you, and no criticism of you is intended.
None taken. All right. Yes, Commissioner Yates.
New business?
Yeah, go ahead.
Go ahead. Repeatedly, over the course of the last 10 months or so, I and Commissioner Jacob and I think Commissioner Weissman have pointed out that in the absence of an appointee by the Senate Democratic leader, that the work of this commission is mightily hampered. I might say, even though the statute says, I believe, that an appointment's to be made within 30 days, I think it's been 10 months or a year that seat is vacant. For people who complain about the voting structure of ACOP, especially people who feel that a negative vote by an appointee can prevent or help prevent or hinder an investigation of somebody within the appointing authority's party or connected somehow or other to the appointing authority. This is a classic example of one of the problems that are created when a vacancy is left open. A vacancy that's left open, just so we're clear, is in effect a no vote on any attempt to investigate a matter. So as long as there's a relatively recent vacancy that applies to the assembly appointee, but there's a long-standing one for 10 months that we've complained about continuously. And it seems odd to me when I hear that there are people within the Democratic Senate caucus who are pushing for amendments to the structure of JCO to complain about a lack of investigation when they, in fact, are hampering an investigation by putting a perpetual no vote in place by continuing a vacancy.
Thank you. Okay. Attachment D, the proposed meeting schedule.
I'd like to add.
Go ahead, Marvin. Go ahead.
The statute that involves the appointment of commissioners to this commission provides for 14 members, as you all well know. We are now operating with 12. The 12 members consist of 6 appointments made by the governor, and they are complete. And as Commissioner Yates pointed out, the legislative appointees are not complete because there are 2 vacancies. One created by Commissioner Dawn Smalls about a year ago, and the other an assembly appointee, which is rather recent. But the statute creates I think, a near perfect balance where it provides for the governor to appoint the chair of this commission, but then tries to balance that with 8 legislative appointees, meaning 8 and 6. When you're deadlocked, as we are, on a 6 to 6 or a 7 to 6, the statute's objective, in my view, is frustrated. Whether we are talking about investigations, as Commissioner Yates just mentioned, and perhaps more importantly, about a vacancy in the position of executive director, it takes 8 commissioners to pass anything at this commission, whether on investigations or to appoint an executive director. But now we are in a sort of deadlock. Nevertheless, we are confronted, as Commissioner Yates said, by all these attacks upon us that we do not do this, that, or the other thing. Yet the very same people who criticize us do not make sure that we are fully constituted with 14 members, which creates the balance contemplated by the statute: 8 legislative, 6 gubernatorial appointees. Now, they can keep these open as long as they wish, and we remain in a state of paralysis on many issues. And the reason Commissioner Yates and I raise this again today, although we've been raising it for months and months, but we're raising it with some greater detail. With all respect to the appointing authorities, who I am sure are quite busy in the legislature with the good work they do, we are constrained to say these things so as to get this commission moving on a number of issues. And if anyone else wants us to, and I've been emailing about this to other members at the commission, and they've been emailing to me, which only emphasizes the frustration we all feel on this subject.
Anyone else? Thank you, Commissioner. Okay, let's move to the legislative recommendation.
So, just given where we are in the meeting and the fact that you're forming a committee which relates to some of the recommendations, I think staff would be inclined to just table this discussion for a future meeting unless any commissioner wants to discuss a legislative recommendation at this time. Yes, go ahead.
Okay, let's move on then.
So then the proposed meeting schedule is behind, I think, tab B. And this is excluded at this point for commissioners to review, to see if they have any conflicts. If you do, please let Martin or me or Kelly know that you have a conflict, and then we will come back with the final schedule at the next meeting.
Okay, unless there's anything else, that wraps up the public session. At this point in time, I need a motion to enter into executive session. Thank you, Commissioner Yates. Second.
Commissioner Horowitz.
Commissioner Horowitz, all in favor?
New York City.
Albany.
Buffalo, Albany, and WebEx.
Okay, we are adjourned.
Stand by.
Yes.
We're back. Great. And we're back from executive session. Monica, can you report on what we did?
Sure. The commission discussed litigation and personnel matters. The commission granted 2 applications for an exemption from the post-employment restrictions pursuant to Public Officers Law, Section 73(8)(b). The commission approved 1 settlement agreement. The commission commenced 2 substantial basis investigations, and the commission authorized steps in several other investigative matters, closed 1 matter, and discussed several investigative matters.
Great, thank you. Is there a motion to adjourn?
So moved.
Is there a second?
Do we have?
All in favor?
Commissioner Yates, seconded.
Great, thank you. All in favor?
Aye.
Okay, great. And that's it.
We have 2 in New York City.
2 in Albany.
2 in Albany.
WebEx.
All right, that's 8.
Great.
Thank you.
Thank you. Take care.
Post Fisher Gates, correct?
We're Stein.
Unanimous.